Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a case that has just been decided by the Supreme Court of Canada that deals with property rights and government expropriation. The case is called Annapolis Group and Halifax Regional Municipality, and it's about something called de facto expropriation. Now, expropriation is when the government seizes private land for a public purpose, and when they do this, they need to pay the owner compensation. A de facto expropriation, also known as a constructive or regulatory expropriation, occurs when title to the land doesn't change, but in all other senses, there is an expropriation. For example, when the government places restrictions on the use of land without formally taking the property. That's what happened in the Annapolis case. In that case, a property developer owned 965 acres of land in Halifax, zoned for development. And Annapolis says that Halifax arbitrarily refused their request for development and kept that land undeveloped for 15 years. Halifax then further promoted the privately owned Annapolis lands as a public park by allowing trail signs to be posted on them with the Halifax logo. They say, Annapolis says, that Halifax did this to get a park for free. Here today to talk about the case and the law of expropriation are two experts. Joanna Baron, the executive director for the Canadian Constitution Foundation, the charity I work for, and Malcolm Lavoie, the lawyer who represented the CCF in this case. Now, thank you both so much for joining me today. Joanna, let's start with you. I outlined some of the facts in this case. Why don't you give me a little bit more of that background?
Yeah, so as you mentioned, Annapolis is a property developer that owned a lot of land in Halifax. And this particular parcel of land that we're talking about in this case happens to be beside a designated wilderness area. Halifax undertook in 2006, I believe, to undertake the development of a regional park beside the wilderness area. And the proposed park included the lands owned by Annapolis. Despite that, Halifax, for whatever reason, which we will surmise, didn't end up zoning these lands owned by Annapolis for a public park, and they were zoned for residential development. However, as we know, development can't proceed until it goes through the requisite regulatory processes, until it's approved by the city during the planning process. And throughout many years of efforts, Annapolis was just hitting roadblock after roadblock in attempting to get approval to go ahead with the development of this land. And then they resorted to the courts. Because in the meantime, while all of this was happening, there was some evidence that Halifax did things like put up signs on the land promoting it as a city park without formally changing the title.
Now, Malcolm, government can expropriate property. I mean, there's a lot of well-known stories about property being taken by government for various things, airports, highways. What makes a de facto or a constructive expropriation different?
Yeah, sure. Governments can expropriate. Generally speaking, in order to take away the property rights, there has to be a statute that authorizes that to take place. And generally speaking, where an expropriation takes place, there's a right to compensation, either provided for under the statute or presumably applying just because there is a taking of property. And so the typical scenario is a scenario where the government's actually taking title to the property. The government becomes the owner of the property. What makes a de facto expropriation or a constructive taking different is that the government doesn't actually become the owner on paper, but rather the courts are saying that the conduct in question, while not formally an expropriation, while not formally taking away the property interest in the object of property, it nevertheless amounts to the same thing. You fundamentally deprive the owner of her right in the resource, such that from the owner's perspective, at least, it amounts to the same thing as the government taking away the title. And so this doctrine has been developed over time by the common law courts, essentially as a means of preventing governments from doing indirectly what they can't do directly. Generally speaking, governments can't take away title to property without compensation. The doctrine of constructive takings or de facto expropriation says, well, you can't do the same thing indirectly by, say, preventing development and trying to get a park for free.
Now, in this case, the Supreme Court didn't actually decide if a constructive taking or regulatory de facto taking had occurred. That's going to be decided by another court. But what they did do is change the test about what constitutes a de facto or constructive expropriation. We've got to go to commercial break, but when we come back, we're going to talk about what that test is. Welcome back to Canadian Justice, where we're discussing a recent Supreme Court decision about property rights and government expropriation. So, Joanna, before we get to what the Supreme Court decided in this case, let's talk about what the law was up until now on when a constructive or de facto expropriation takes place and why that existing law, that existing test, wasn't enough to protect property rights.
So the guiding precedent from 2006 asked whether the government had taken the term as beneficial interest in the land in question. And in practice, the courts tended to interpret that as ownership rights, which is obviously a pretty stringent test that would exclude a number of situations, such as apparently this case where you have a land that is functionally unusable by the property owner, but where there isn't a change in ownership. So it was a very stringent and, we argued, unworkable test.
Yes, under that test, the lower courts had come to a different conclusion. Now, this case at the Supreme Court has sort of reformulated the test for when a de facto expropriation takes place. Malcolm, what can you tell us about what the Supreme Court held in this case?
Yeah, so probably the biggest takeaway is the court clarifying what is meant by a beneficial interest. So the test in the CPR case, as Joanna mentioned, involved two elements: what the government gets, the beneficial interest, and what's taken away from the owner, the requirement that the owner be deprived of all reasonable uses of the property in question. And that beneficial interest requirement was generally understood to be quite strict. There were suggestions even that it had to amount to a property interest, which would of course make constructive takings basically the same thing as formal expropriation, because formal expropriation is when the government takes a property interest. And so here the court doesn't overturn the 2006 CPR case. It's careful to stay within the confines of the terms of that test, but it clarifies the test in a way that really opens up more room for claims to compensation. Specifically, they say that a beneficial interest should be interpreted broadly to mean some kind of advantage flowing to the government. That is much broader than a property right, certainly. And indeed, when the government enacts regulations that take away an owner's ability to benefit from property, it can generally be presumed that it's doing that in order to get some kind of advantage out of the situation, or else why would it do it? And so this really broadens the test for constructive takings or de facto expropriation, and puts the emphasis of the test on the effect of the government measure on the owner, as opposed to what the government gets.
Joanna, is there anything you want to add to that about the Supreme Court's decision and how this might benefit property owners?
Yeah, well, obviously, it's a much more flexible approach that recognizes the many different ways that government regulation and government action can deprive an owner of their rights. I also would add that, in spite of, we may talk about this later, despite the fact that property rights are not protected in the Charter, there was a really rich discussion about common law property protections law, and that the Charter is not the only source of rights. And the majority in this decision drew a lot on common law property protections to arrive at their decision.
Now, Malcolm, the Supreme Court actually, adopted some of the arguments that the CCF had made in our factum the factum that you wrote, because we were an intervener in this case. So, what can you tell us about what the CC argued that the Supreme Court adopted?
Yeah, great question. I was really gratified with the result, and I think we made a significant difference in this case. You can see the influence of the Canadian Constitution Foundation's factum throughout the majority decision, and I've got 5 points that I'd highlight that really come out of our factum and our arguments.
Well, we've got a minute. We've got 1 minute, so you can go into the next segment. But let's start with the first few.
I'll be quick. Yeah. So, firstly, the court clarifies there's a common law right to compensation. The right to compensation doesn't come from the statute. when the government takes property. Secondly, the court characterizes past case law in a way that essentially aligns with what we argue, that says these past cases, they're not about the government taking away a property interest, they're about the effect on owners. Thirdly, there's that beneficial interest requirement. We argued for that broad interpretation of the beneficial interest requirement and that the emphasis should be on the effect on owners. Fourthly, there's a list of a range of examples or indicia of constructive takings that the court adopts that essentially comes out of our factum. And finally, there's that emphasis on the importance of common law rights, the idea that Canadians' rights didn't start with the Charter in 1982. That too was present in our factum, and I think we influenced the court on that point.
All 5 in under a minute. It's why you're such a great advocate, Malcolm. We'll be right back. Joanna, in this case, the Supreme Court has reformulated or clarified the test for when a de facto or constructive expropriation takes place. But what does that mean for the property developer in this case, Annapolis, who alleges that the city of Halifax was trying to get their property as a park for free? What happens to their claim that Halifax took their property? What's next for them?
So what had happened was Annapolis had initiated a lawsuit against Halifax. Halifax had moved for summary judgment, which is basically just to have the case dismissed at a preliminary stage. The motion judge had rejected that and said that there was a serious issue to be tried. And then that was later overturned. So basically they can go back and bring this claim to trial under the expanded, revised, clarified test that we've just been speaking about.
So Joanna, we talked a little bit about common law protections for property rights, which are sort of ancient. But what a lot of Canadians might be surprised to learn is that we don't actually have a constitutional protection for property rights. And it's very well known that our neighbors to the south have that constitutional protection. So what can you tell me about maybe why we don't have a constitutionally protected property right in Canada?
Yeah, I would mention that Malcolm had a great piece during the Emergencies Act scandal where the bank accounts were frozen, that part of why that was so difficult to remedy is because we don't have constitutionally protected property rights. But that's just an aside. I thought it was an interesting tie-in. But anyways, it's not for want of trying. It was the policy of Pierre Elliott Trudeau. It was the policy of the Liberal government when they started negotiations for the Charter that the right to property should be protected. But for complex reasons, in part opposition of the provinces, some historical circumstances, some legal confusion, in the final mix, property rights did not make it into the Charter. And we've certainly seen the repercussions of that.
Malcolm, is there anything you want to add to that, to our history of our Constitution and why those rights aren't enshrined? And maybe would enshrining them, give us better protections?
Yeah, I mean, I think there's a strong case to be made, and there's some scholarship by Dwight Newman and Laurel Binion about this. There's a strong case to be made that the exclusion of property from the Charter was quite historically contingent. It could have been otherwise. For instance, if the notwithstanding clause was introduced earlier in the process, provinces would have had less reason to oppose it, I think. And similarly, there was some political maneuvering in Parliament where it seemed like the NDP caucus, who were opposed, were a little more effective than the Progressive Conservative caucus, which supported property rights. And so I think it really could have been otherwise. What impact has that had on Canadian law? Well, property rights aren't radically insecure in Canadian law, right? The political branches of government have some commitment to protecting property rights. But that said, there are cases of where abuse has taken place that could have been corrected by a constitutional protection for property. The Authorson case is one example where the government essentially immunized itself against claims by disabled military veterans, 2003 case. And similarly, the case involving the emergency financial measures, whatever you think about the necessity of those measures, they had a huge impact on some of the people who were affected. And the fact that you may not have serious constitutional scrutiny because they only affected property interests, that's a serious matter. And so I think it has had an effect on Canadian law.
Malcolm, the Supreme Court gets into this a little bit in the Annapolis decision, but just because we don't have constitutional protections for property doesn't mean that we lack property rights, as you've said. So what can you tell me about the inherent rights, property rights that we have, and the sort of ancient nature of those rights at common law?
Yeah, absolutely. So there's a few different ways to approach this. Firstly, property rights are protected indirectly through the separation of powers. One of the big narratives of British constitutional history was over time the gradual development of constraints on the ability of the crown or the executive to take property without being authorized by the legislature. So this requirement that if you're going to take property, the legislature has to actually authorize it. That's a kind of constitutional protection. It says the executive branch can't just take property on its own. And similarly, the courts have reinforced those protections. They've said that if you have legislation that takes away property, that legislation has to be clearly worded. You can't have, if there's an ambiguous statute, it should be interpreted in favor of the property owner. And the development of the doctrine of constructive takings or de facto expropriation, that's a further common law development that adds protections for property, saying that governments can't take away property indirectly through regulatory measures. And so you have a range of common law protections that are ultimately subject to the ultimate authority of the legislature.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing property rights and government expropriation. Now, Malcolm, in this case, Annapolis, the court has clarified or maybe even broadened the test for what constitutes a constructive taking or de facto expropriation, sort of made it easier to claim. What is that going to mean for cities or other levels of government in the future? Are they going to need to conduct themselves differently?
Yeah, good question. So this doesn't just apply to municipalities in the development context. This is a general right to compensation. So it would apply to other levels of government in other contexts that amount to a taking of property. We should say at the outset, most government regulation, even regulation that diminishes the value of property, isn't going to meet the standard, right? You need a deprivation of all reasonable uses of the property. And so most regulations aren't going to meet that standard, but where you have a regulation that really has the effect of essentially depriving the owner of the benefit of property, whether it's in the development context at a municipal level or whether it involves another order of government, there's a presumptive claim to compensation unless you have a statute that specifically says no compensation is required. And so, these claims have been brought in different areas of law in the past, not just in the context of developers that can't develop, but you can have in cases involving mineral interests where minerals can't be developed, where the government there's a case from Newfoundland where the government essentially just builds a road over private land and occupies it. And the court says, well, you can't do that even though you didn't take title without compensation. So there's a lot of different areas in which you could have these claims, and a lot of different ways in which government action could amount to a constructive taking.
Now, Malcolm, before I turn to Joanna, there was a dissent in this case. So, what can you tell us about the dissent's perspective?
Yeah, so this was a closely decided case. It was a 5-4 decision. And there were four justices that did not agree with the majority's approach. The dissenting justices essentially took the position that the majority was changing the law. As I mentioned, the majority framed their analysis as essentially clarifying the CPR test, the beneficial interest requirement especially. And the dissent says no. Beneficial interest essentially means some kind of proprietary-like interest. And this development of law is a change in the law. It doesn't respect precedent. And Annapolis's claim should fail because it doesn't amount to essentially the municipality taking a property interest.
Well, Joanna, this is not the only case that the CCF has done on property rights. What are some of the other, I mean, it's a big area of priority for our organization. What are some of the other cases that we've done on the topic of property rights?
So we represented a husband and wife called the Rileys, which were a couple that owned a number of rental properties that they rented out actually at like below market rates to help the local community. And the government came to surmise without really evidence that because there was some connection of some drug dealers connected to some of the properties, that the proceeds of the properties, the rents, were being paid by drug money, even though that wasn't made out at all. And they allowed the properties, which were very valuable, to fall into complete disrepair. And so we represented their interests in that case some years ago. And then last year, we had a case at the Ontario Court of Appeal called Norwood Estate, where we contested the fact that a forced settlement was approved by a deceased individual's estate and his mother, who made a claim for a portion of the estate, even though any determination about whether the estate was connected to the proceeds of crime. We've also done lots of work and research on civil forfeiture. You can download a civil forfeiture report, which we should update soon on our website. So it is a huge priority for us, but obviously this is a huge win for us.
Yeah, civil forfeiture is a fascinating area of law where the government can seize property if they allege that there's some connection to crime. For example, if my brother uses my car to distribute drugs, the government could then come and take my car, even though I have no association with crime whatsoever. Neither does my brother, just as a hypothetical. But it's a fascinating area. I want to thank you both so much for coming on today to discuss this case.
Thank you.
Thanks, Christine.
We've heard today about government expropriation, including constructive or de facto expropriation. The right to own property lies at the core of liberal democracy. Protections for property can be traced back to the Magna Carta and the English Bill of Rights from 1689. Ask yourself, how would you feel if the government took your land away from you? How can we better protect our property rights from governments? And is this case a step in the right direction? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.